Attorney General Jeff Sessions, left, and Chief Justice Roger B. Taney saw LoebGetty images in the Library of Congress. Throughout his presidential campaign, Donald Trump maligned undocumented immigrants as violent criminals and sexual predators who deserve to be rounded up and deported. Once in office, Trump transformed this rhetoric into policy, implementing a nationwide crackdown on immigrant communities. Now, the president's dehumanizing disparagement of undocumented people has seeped into his administration's legal positions. This week, the Department of Justice is arguing in court that undocumented, unaccompanied minors have no right to abortions, and that undocumented immigrants may have no constitutional rights at all. This argument does not only contravene Supreme Court precedent, it also draws upon an inhuman notion of constitutional liberty most notoriously espoused in Dred Scott v. Sanford. The Justice Department's radical new theory arose out of a disturbing case in Texas that revolves around a 17-year-old referred to as Jane Doe in court filings. Doe arrived in the United States several months ago, unaccompanied by her parents and lacking documentation. She was placed in a federally funded Texas shelter, at which point she learned she was pregnant. Doe requested an abortion, but under state law, minors cannot receive the procedure without either parental consent or judicial approval. So Doe obtained what's known as a judicial bypass and asked permission to attend a state-mandated counseling session before undergoing the procedure. Her shelter refused to allow her to attend that counseling session, citing federal regulations promulgated by the Office of Refugee Resettlement, a wing of the Department of Health and Human Services. In March, OR announced that federally funded shelters could not take any action that facilitates abortion for unaccompanied minors, including scheduling appointments, transportation, or other arrangement, without direction and approval from Scott Lloyd, the agency's director. A Trump appointee and longtime anti-abortion activist, Lloyd has refused to allow minors to access abortion services. Instead, he has directed shelters to take these women to crisis pregnancy centers, which counsel them not to get abortions. At least once, Lloyd himself called a pregnant minor to talk her out of terminating her pregnancy. If a minor still wants to get an abortion after navigating these obstacles, OR instructs its shelters to block her from attending her appointment. This shelter followed these guidelines, taking her to a crisis pregnancy center and calling her mother to tell her Doe was pregnant. But Doe persisted, and in October, her court-appointed attorneys filed suit along with the American Civil Liberties Union in a federal district court in Washington, where OR is headquartered. Doe argues that OR's rules violate her constitutional rights by placing an undue burden on her access to abortion. On Wednesday, U.S. District Judge Tanya Chutkan held a hearing in the case. While defending the government, Department of Justice Attorney Scott Stewart strongly implied that undocumented women do not have a right to abortion. Here, Stewart was echoing an amicus brief filed by the Texas Attorney General's office, which proclaimed that unlawfully present aliens living in the United States have no constitutional right to abortion access. Chutkan then asked Stewart whether Doe has any constitutional rights. Stewart declined to make that concession. Chutkan ruled against the government and issued a temporary restraining order guaranteeing Doe the ability to terminate her pregnancy. She is currently 15 weeks pregnant, and abortion is illegal after 20 weeks in Texas. The DOJ appealed to the U.S. Court of Appeals for the District of Columbia Circuit, which will hear arguments in the case on Friday morning. In its motion, the agency argued that the government's interest in promoting fetal life and childbirth over abortion justified its refusal to let a minor go to an abortion clinic. It also claimed that, even if undocumented minors have a constitutional right to abortion care, the administration was not unduly burdening that right, because minors who want to terminate their pregnancies can leave the country. This argument is merely another way of stating that women like Doe have no right to an abortion in the United States. By excluding undocumented immigrants from the protections of Planned Parenthood v. Casey, the Trump administration is essentially asserting that they do not qualify as persons under the due process clauses of the 5th and 14th Amendments. The Supreme Court has ruled that the liberty component of the due process clause protects a woman's right to terminate her pregnancy without a substantial obstacle. If arbitrary regulations that severely burden clinics qualify as such an unconstitutional obstacle, as the Supreme Court has held, then surely self-deportation does as well. Thus, the sole plausible interpretation of the DOJ's posture is that the Due Process Clause does not protect undocumented women like Doe. Put simply, undocumented women are not people for constitutional purposes. This theory parallels the Supreme Court's most infamous ruling. Dred Scott was a black man born into slavery who moved with his master from a slave state to a free state. Upon his master's death, Scott sued for his freedom. In 1857, Chief Justice Roger B. Taney, a virulent racist whose statue was removed from the grounds of the Maryland State House in August, wrote an opinion dismissing Scott's suit. Taney held that black people were not persons based on the language of the Constitution and that Scott, as a black man, therefore had no right to sue in the federal courts. Black men, Taney wrote, were so far inferior to whites that they had no rights which the white man was bound to respect. Following the Civil War, Dred Scott was overturned by the 13th and 14th Amendments. These amendments ensured that everyone born in the United States would be a citizen. They also granted all persons, not just citizens, due process and equal protection under the law. Trump has already raised the specter of Dred Scott through his call to end birthright citizenship, the constitutional command that lay at the heart of the Civil War amendments. Now his administration is invoking the decision again in its attempt to deprive undocumented immigrants of their personhood under the Constitution. The government has rarely alleged that undocumented immigrants may be deprived of rights protected by the liberty component of due process, what's also known as substantive due process. Its few attempts have been unsuccessful. In 2003, the Bush administration argued that substantive due process does not apply to immigrants who reside in the country illegally. The Sixth U.S. Circuit Court of Appeals, sitting en banc, emphatically rejected this claim, explaining if excludable aliens were not protected by even the substantive component of constitutional due process, as the government appears to argue, we do not see why the United States government could not torture or summarily execute them. We do not believe that our Constitution could permit persons living in the United States, whether they can be admitted for permanent residence or not, to be subjected to any government action without limit. Perhaps recognizing the extremism of its argument, the Trump administration has left open the possibility that undocumented immigrants are entitled to some unspecified minimal standards of constitutional protection. But if those minimal standards don't include the basic right to bodily autonomy, then the Sixth Circuit's query still stands. If the government can force Doe to carry her pregnancy to term against her will, what can't it do? The administration's attempt to exert complete control over Doe's reproductive system is a straightforward deprivation of constitutional liberty that opens the door to equally egregious future abuses. On Friday morning, the Justice Department will return to court once more to argue, in effect, that Jane Doe is not a person worthy of due process protections. It might as well cite Dred Scott for the proposition that the government may strip undocumented immigrants of their constitutionally protected liberty. The 14th Amendment was designed to end such capricious discrimination against individuals living in the United States. But to the Trump administration, immigrants like Doe aren't even people, just possessions of the state, awaiting deportation.